Uh, and thanks to everybody for joining our CLE this morning. My name is Alexander Villardo, and I'm co-chair of the Educational Committee of the UB Law Alumni Association's Gold Group. Today's presentation is titled Federal Trials During the COVID-19 Pandemic and features Chief Judge Frank Geraci of the Western District of New York. This is one in a series of many virtual programs the Law Alumni Association and the Gold Group are hosting as a service for our alumni and law students. If you are interested in attending other upcoming webinars and CLEs, you can register on the UB Law School website. You can also listen to past CLEs and other webinar recordings at no charge on our new alumni education webpage, also located on the law school website. To get discounts and select free 1-hour CLEs, please consider becoming either an annual or lifetime member of the UB Law Alumni Association. And finally, I'd like to thank our Gold Group sponsors, Chicago Title, Counsel Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution LLC, Paramount Settlement Planning LLC. Now, a few brief housekeeping points. You'll be muted during the course of this presentation. If you have a question at any time, please use the chat room and we will try to address it during the Q&A portion at the end of the judge's lecture. At some point during the course of the CLE, I'll announce the course code and we will also place that in the chat room. So please be sure to catch it, as you'll need the course code for the online attorney verification form that was included in the registration page. This form is required for you to get CLE credit. Please also return the program evaluation form found on that page. Now it's my great pleasure to introduce our speaker today, the Honorable Frank P. Geraci Jr., the Chief Judge of the Western District of New York. On 2nd, 2013, subsequent to confirmation by the United States Senate, President Obama signed a commission appointing Judge P. Geraci Jr. to the United States federal bench to serve as a district judge for the Western District of New York, where he currently presides. On March 9th, 2015, Judge Geraci became the Chief Judge of the Western District of New York. Previously, Judge Geraci served as a Monroe County Court Judge from 1999 to 2012 and a Rochester City Court Judge from 1992 to 1998. Judge Geraci actively supported alternative programs designed to help break the cycle of criminal activity in the Rochester community. The formation of the Day Reporting Center, the Rochester Drug Treatment Court, and the Rochester Teen Court are some examples of that activity. A lifelong resident of the city of Rochester, Judge Geraci is married and has 4 children and 6 grandchildren. Judge Geraci is a graduate of the University of Dayton and the University of Dayton Law School. Between college and law school, Judge Geraci served as Deputy Clerk of the City Court of Rochester. He served as a Special Assistant District Attorney in Monroe County from 1978 to 1983. In 1983, Judge Geraci was appointed as Assistant U.S. Attorney in the Western District of New York. As an Assistant U.S. Attorney, Judge Geraci also served as an instructor in the U.S. Attorney's General Advocacy Institute in Washington, D.C. In 1987, Judge Geraci formed a partnership with Jonathan Feldman, who later became a U.S. Magistrate Judge. The law firm of Geraci and Feldman specialized in civil and criminal litigation. Judge Geraci has been active in the Monroe County Bar Association, and he has also served on Monroe County's Graduated Restriction Advisory Board, the Monroe County Catholic School Board, and the Diocese of Rochester's Bishop Matthew Clark Stewardship Council. Judge Geraci has also served as co-chair of the 7th Judicial District Committee to promote trust and confidence in the legal system, president of the University of Dayton's National Alumni Association, chair of Our Lady of Mercy High School's Board of Governors, president, coach of Rochester's Eastside Little League, and assistant coach for Catholic Youth Organized Basketball. He was an adjunct professor at St. John College, and we were fortunate enough to have him as a visiting professor at UB School of Law. So without further ado, I'll turn it over to Judge Geraci.
Thank you, Alexander, for that nice introduction. First of all, I brought my Boston face mask for Sean Eldridge, who I see is online right now, another Boston fan. I have a great affinity for UB Law School. I've hired a number of their graduates, including Sean Eldridge and Annie Modica, I know it's a great school, and I was fortunate enough to receive the non-alumni award a few years ago, and it was quite an honor. So I have a lot of respect for UB Law School and the graduates of that law school. So thank you for inviting me to do this. We're in a very, very odd era. These are times that are very troubling. As a chief judge, I have a responsibility to carry out my duties as a judge, as a trial judge, and administrate my own caseload. But I also have a great administrative duties throughout the district. But those got tremendously compounded in March of this year when we were here with this COVID crisis. We spend time trying to manage cases and move cases along and try cases and sentence individuals fairly. But this is really a matter of life and death. I put together a team, a task force, purposely to be sure that we could continue to carry out our duties, but do so safely for the public, for the attorneys, and for the litigants in this courtroom. And it's been a struggle, quite frankly. Up to last week, we were very fortunate. We had nobody positive with the coronavirus in either the Jackson Courthouse or the Keating Courthouse. And then last Friday, things exploded, and we have 4 positive individuals. Now it's, I think, up to 5 or 6 entering the Jackson Courthouse. Knock on wood, we still have not had anybody enter the Keating Courthouse positive for the coronavirus, but it's probably going to happen at some point. I'm going to go through, take about a half an hour to go through the steps we've taken to handle this situation and how it affects trial attorneys and trying cases in our courthouses. As you know, this happened very suddenly in mid-March of this year. Seems like last year. And I quickly put together a coronavirus task force, a very small task force of 4 people. That's myself, the clerk of court, Mary Longuth, the U.S. Marshal, Charles Salina, and the Chief Probation Officer, Anthony Sangiacomo. And the reason I kept the group small was because things happened very, very quickly. And we had to make decisions very quickly, get information out, keep the judges in the loop. The decisions themselves were made by the court. In other words, we could make a recommendation as a task force, and then I would reach out to the judges. As a court, the board of judges would make the ultimate decisions on how to proceed in every step of the way. Communication was a real challenge. I have a binder that has probably about 1,200 pages in it now of materials and communications I've made with our court family and our judges throughout this crisis. It's been quite a challenge. We activated right away the COOP plan. The COOP plan is a continuing of operations plan for any emergencies. For instance, if there's a flood or an earthquake, we have a plan set in place for that. So we immediately activated our COOP plan for the Western District of New York. We imposed visitor restrictions right away. The CSOs at the front of both Keating and Jackson Courthouse began screening individuals before they entered the building, asking them initially, it was if they were in another country, because the initial concern was people coming from Italy, Spain, China. Of course, that has expanded now to almost every state in the United States. So they continue to do that type of screening. We also had to seek protections for the CSO, get equipment for them. We've spent about $50,000 on personal protection equipment for jurors, for staff, for the CSOs and things of that sort to make sure that everybody was safe. We initially basically closed off most of the courthouses in Jackson and in Keating. And what we did is we literally put tape across the doorways of offices and courtrooms so that they wouldn't be entered, so that we could focus on certain areas to keep clean, common areas, the hallways, elevators. And we had 2 courtrooms in each courthouse designated for any proceedings we had to have. Of course, we had to go remote, send almost everybody home. Our IT staff had quite a chore in making sure that everybody was equipped with computers and access to our system so they could perform their duties by way of telework. And quite frankly, that worked very smooth. People were able to conduct our business from their homes in different locations, and that's worked out quite well. The U.S. Attorney reached out to me right away, J.P. Kennedy, indicating that he was going to have a problem functioning grand jurors in the grand jury space because we had to socially distance, and to socially distance that group was going to be difficult. So we immediately designated a courtroom in Jackson and a space in Keating so that he could continue to function the grand jury. We halted new grand juries, the impanelment of new grand juries, but we were allowed the grand jury functions to continue. And we were the only district in the Second Circuit to do that, and one of the only districts in the country to continue grand jury proceedings. So they've never stopped. And eventually we got to the point we were allowed to impanel new grand jurors as well. So we've really been able to conduct our business on a pretty regular basis. The clerk's office remained open throughout. Again, a number of clerk's offices throughout the country were closed. Ours never closed. We never even reduced the hours for the clerk's office. Some did. We put a drop box outside the clerk's office and also at the entrance to the building so people could drop findings without having to go to the clerk's office, and reduce staff to a skeleton crew. All the judges in their chambers began teleworking almost immediately. Because electronic filing, of course, findings continued both in the civil and in the criminal end, even though the numbers were pretty significantly reduced in the criminal side, about 25%, in the civil side, only 5%. We were able to allow people to continue their work. We moved to a Zoom government platform. I know there was some criticism initially and about Zoom itself, but we have a special Zoom government platform which is very secure. And by that, we're able to conduct remote proceedings. Because of the CARES Act, we were able to get authorization from Congress to conduct proceedings remotely and by video conference that were not allowed previously under our criminal procedure. I'm hoping that that gets extended beyond this crisis because we found it to be a very efficient way of conducting business. In other words, prisoners, we have them set up in the jail where we can arraign them, we can sentence them, we can take pleas on individuals, and that prevents the marshals from having to transport them from a local courthouse to our courthouses, and that obviously is a lot more secure. We're finding it's also a lot more efficient to conduct in that manner. One of the real struggles early on were for attorneys because a lot of the local jails restricted visitation. So it's very difficult for attorneys to meet with their clients. They were able to set up remote meetings on occasion, also personal meetings on occasion so that they could conduct their business. But I know it's been a real challenge for defense counsel in order to prepare for proceedings in the courts. We did issue a number of orders expanding time periods. For instance, speedy trial is an issue in criminal cases. And we did issue a general order excluding the time based upon that crisis, particularly in light of the fact that in trials, anyways, in criminal trials, we could not conduct trials because we could not get jurors to come in. People in the beginning, there was great fear about this virus. There's really a lot of speculation. Nobody really had their handle around it. And when everybody's watching the news out in New York City in particular, there was tremendous fear. So we had a good basis for excluding time under the speedy trial statute in the interest of justice. And we did that for significant periods of time. Every 60 days or so, I would issue a new order doing that. And we had no resistance. And quite frankly, I want to commend both the U.S. Attorney's Office and the defense bar along those lines. They've been tremendously cooperative throughout this crisis and have done a good job for their clients, respectively, both the U.S. attorneys for the interest of the United States and for defense counsel for their individual clients. So, sometimes people do the best in a crisis, and I'd say we've seen the best in attorneys throughout this particular crisis. One of the things that judges love doing, federal judges, and I think all judges, is conducting naturalization ceremonies. It's a real pleasure to stand before a group of individuals and see the pride on them when they are made citizens of the United States. And I presided over a number of those proceedings, but we could not do those safely, and we had to cancel all naturalization ceremonies. Consequently, I granted authority to the Naturalization and Immigration Service to conduct those proceedings administratively. So people are still becoming citizens, but it's not in the ceremonial context that we've had before, which is, as I said, such a fun thing and such an exciting thing to do. So hopefully we'll get back to that pretty soon. Attorney admissions have been done pretty much remotely as well. We used to have attorneys come in so we could introduce ourselves to them and have them introduce themselves to the court. It's, I think, a great moment for attorneys to be introduced and to be admitted to federal court. We've had to do that by way of remote, so it's not quite as it was an exciting proceeding, but we're able to continue to have attorneys admitted to our courts. One thing that was suggested by the CJA panel, that's Criminal Justice Administration panel attorneys, was that we consider issuing interim vouchers. In other words, typically attorneys do not get paid until the proceeding is ended and they submit a voucher on that. Well, under the crisis, attorneys were not getting new clients, were not getting new cases, and that was going to create a tremendous hardship to them. So we did and now allow interim vouchers to be prepared and submitted to the court for payments along the line as a criminal proceeding is continuing, and that's worked very well. And I think that's probably something that we could probably support continuing again past this crisis because it's worked well. As we moved along, of course, we're not experts in this disease, and we wanted to be sure that as we were going to get back into the business of conducting proceedings in person, we had to do it the right way. So we hired a doctor from the University of Rochester, Dr. Brenda Tassini, who is an infectious disease specialist. She came to both Buffalo and Rochester, walked through our courthouses, all our offices, all our courtrooms, and made suggestions for us how we could conduct proceedings safely. Things that we wouldn't have thought of. For instance, in the restrooms, the public restrooms, where there is the possibility of having 3 or 4 people in those restrooms, she suggested that is not a good idea to only have one person. Close off our jury deliberation rooms. They simply weren't big enough for social distancing. And we have refrigerators in those rooms so that jurors could bring their lunches. She suggested we not allow the use of any refrigerators because of possibility of cross-contamination of lunches they may bring in there. Things we really may not have thought of but for her expertise. And of course, the socially distancing, marking off courtrooms so that we could have individuals safely come into our courtroom was all done only after consultation with Dr. Tassini. So she's been a tremendous help. We had to set up a system for contact tracing. If we found out that an individual had contact with somebody who was positive for the coronavirus, we had to then track what contact did they have in our courthouse? Who did they meet with? What offices were they in? What courtrooms were they in? What judges did they meet with? In order to be sure that we could secure those areas, clean those areas, and be sure that everybody was safe afterwards. And that's a process that we've kind of finessed over the past 9 months. And we've been very, as I said, very fortunate for the most part up till now. We have a very conservative approach to this. In other words, somebody doesn't have to be just positive with the coronavirus to be quarantined from our courthouse if it's a staff member. If they have contact with somebody in contact with the coronavirus, we quarantine them out of safety. For instance, an example I gave you, we had a law clerk whose wife was a teacher. The teacher worked in a school where somebody was positive with the coronavirus. Now, the law clerk's wife was not symptomatic. He was not symptomatic, but we kept him out for 14 days, gave him a 14-day quarantine to prevent any exposure to our courthouse. And that type of approach, I think, is why we've been very successful at keeping the virus out of the courthouse for everybody's sake. This has been very stressful. We've held a couple of webinars for our staff throughout this time period in order to explain to them what steps we're taking, what we think the future holds down the line, so we could hopefully alleviate some of their concerns and anxieties. But we realize that just as a society, we're very anxious about this illness and this disease affecting everybody. So we did reach out to a mental health professionals and experts and held a webinar for our staff and the court family so they could ask questions and get advice on how to approach this particular situation. The stress level is tremendous. We have staff members who have young children where they're trying to teach, help them learn remotely at home, while at the same time they're trying to telework, maybe dealing with somebody who's come up with the illness in their home or somebody who's had contact with the illness in their home. And so we understand those stresses that are on our staff and the court family. We try to do everything we can to try to alleviate that. We have mandated the wearing of masks in our courthouses. Nobody can enter the courthouse without wearing a mask. And we've encouraged everybody to wear masks the entire time they're in our courthouses. We've left it up to individuals in their own personal space within their office space on whether or not to wear their mask. But if they're in the public hallways and they're in the restrooms, they're in the courtroom, they're going to wear masks. And of course, I think we've seen now and following the science that this is a very, very critical factor at alleviating the spread of this virus. So we're very strict about that with our court personnel. And any attorneys know when they come into the courthouse that they are that everybody's strict about them wearing the mask. You know, people are tired of this. There's this pandemic. Just people are worn down from it. But if we lower our guard now, I think we could be in real trouble. I think some of the uprise we're seeing both in Buffalo and in Rochester areas are due to a number of factors. According to Dr. Tassini, things like Halloween parties have caused a tremendous increase in our communities of the spread of this virus. Small gatherings of get-togethers have caused an uprise in the coronavirus in our community. So we have to be mindful of that and make sure we can reduce that as much as possible. I drafted a number of standing orders approved by the court to deal with issues such as speedy trial, the suspension initially of both civil trials and criminal jury trials, the impaneling of grand jury proceedings, the continuation of speedy trial exclusions, and as I indicated, naturalization ceremonies. And those orders have been renewed over time. Right now, they're good through December 24th, and I would suspect I'm going to issue another order extending those through February. We are not currently suspending either criminal or civil trials. I conducted the first civil jury trial, I think, in the country on June 15th of this year. It was a very simple case, a pro se litigant in a civil rights matter that was conducted over 3 days. So it was purposely selected as an easy case to handle so we could work on the logistics. And the logistics are tremendous. We have to meet jurors in small groups at the front door, escort them in the elevator where only 4 people can be on an elevator, bring them up to a courtroom or jury assembly room, make sure they're socially distanced in small groups of 25. If you need 100 jurors, you have to do 4 separate groups of 25, as I did in this trial that I'm engaged in at this time. We provide them with masks, our masks, because Dr. Tassini suggested that we not rely on individuals coming in with their own masks. They could bring in masks that have the virus on them. So we provide them with masks. We also provide them with hand sanitizers, tissues for cleaning, a bottle of water. We have designated seats where they are in the courtroom so that they're spread out, socially distanced in order to be protected. We've changed proceedings throughout these past 9 months based upon advice we've gotten not only from Dr. Tassini, but I've been in consultation with the other chief judges in the Second Circuit and judges throughout the country, in particular, judges in Pennsylvania and Ohio, similar to our district, so we could exchange steps that we've taken to deal with this particular crisis, and we found that's been very helpful. We are under the administration office of the courts, the U.S. courts, and quite frankly, they haven't been real helpful. They have a lot of information on their websites, and it takes forever to try to find the information you need on there. So it's been more and more helpful to discuss matters between chief judge and exchange ideas, between districts and change ideas, and our judges within the district, as opposed to trying to get information from the administrative office of the courts. Quite frankly, that office, that entire office, has been on telework since March, and nobody's been in the office since March of this year. So I just don't think they quite understand the logistics of our trying to get back into the business. And they're helpful, but they're not. They haven't been as helpful as I think that they could have been. Luckily, we've gotten a great cooperation from the U.S. Marshals and from the local jails for screening prisoners before they come to the courthouse. Just one example, we had a prisoner from Steuben County, which is about an hour and a half away from our courthouse, who was here, almost arrived at our courthouse. The marshals here checked to see if the person was screened in Steuben before they left Steuben jail. They had not been, so the prisoner was turned around, never allowed into our courthouse. They had to be screened initially at the courthouse before they at the jail before they leave, make sure they don't have a temperature, any symptoms of the virus. When they arrive at our courthouse, outside the courthouse, they're screened again. Temperatures are taken before they're brought into the courthouse. So we're taking all types of measures to protect everybody. As I indicate, the remote proceedings, I think, are working well. We've had some technical difficulties, obviously, as you would from any type of proceeding like that. But for the most part, we found that it's been extremely helpful in a well-run procedure. As you know, the press and the public have a right to our proceedings, and therefore we had to set up a measure to allow both the press and the public to access our proceedings. So if you go on our website, you'll see there's a phone number where members of the public can listen in to any of our court proceedings. If we need to conduct a jury trial, we have to have 2 and maybe 3 courtrooms set up for every trial. The trial itself is done in one courtroom, and I'm going to try to turn my computer around in a second to try to show you the courtroom I'm in now and how it's set up. Well, we have one courtroom for the trial itself in order to socially distance the jurors, the attorneys, the participants, the litigants, and the public. We have a second courtroom, an entire courtroom set up for the jury during their breaks and during their deliberation, so they can socially distance, take off their masks, walk around and relax a little bit. And then we have a third courtroom if we have overflow, the press or the public want to attend a trial. As I indicate, they have a right to do that, and we have to set that up. So we have 3 courtrooms set up for some of the cases if need be. We initially thought we could not conduct multiple defendant trials, but we have been successful at doing that. Judge Arcaro conducted 2 trials in Buffalo, one of which was a multiple defendant case, and he did so successfully. Judge Wolford conducted one here last week, a multiple defendant trial. I think it was with Sean Eldridge, and that was done quite well. It's difficult. They take longer. Jury selection takes longer. The proof takes longer to present. However, we're able to do it in a safe manner, and I commend the attorneys and the judge for being able to do that. I'm currently engaged in a criminal trial in this courtroom 1 in Keating right now. And quite frankly, I think we may be at the end of the road this year. I think we have a couple trials scheduled in Buffalo. I think Judge Bilardo might have one. Judge Arcaro may have one left this year on the criminal side. I don't believe we have any more on the criminal side in Rochester. I have 2 civil trials scheduled in Rochester in December, both which are prisoner cases, civil rights cases. And my guess is that the state correctional facility is not going to be transporting people over the next few weeks because of the increase in the virus throughout the communities. And therefore, those cases will probably have to be put off for another time. So I think we're almost the end of the road for trials in the Western District of New York for this year. We'll certainly conduct those that we need to, but I think we're going to have to probably put off certainly civil case to the future. We had to prioritize the criminal cases based upon speedy trial concerns. One of the nice things that happened during this virus, when we were purchasing personal protection equipment, we discovered that we had 500 N95 masks within our inventory. And we took those N95 masks immediately and donated them to healthcare workers in Buffalo and Rochester, because initially, of course, that was a concern. So we were able to donate those 500 masks to healthcare workers, and that was a kind of a good feel good measure that we were able to take throughout this thing. One of the things we've seen is an absolute flood of applications for compassionate release from prisoners. We've had probably 500 applications over the past few months for prisoners who are asking for early release based upon their potential exposure to the coronavirus. The judge had to review those, determine if it's appropriate. A number of factors are considered, of course, the risk of that prisoner to remain in that facility, how that facility is handling the coronavirus at the particular time, and of course, the original purpose of the sentence to begin with was somebody with a 20-year sentence who served a year or 2 years, asked for compassionate release, would have to be a pretty critical situation for that to occur. On the other hand, somebody who's only has 12 months left on their sentence, who is at risk for contracting the coronavirus, has a severe asthma condition or heart condition, for instance, might be more amenable to getting released and compassionate release. And we've had a few of those. I would say largely they're rejected, but we've had a few individuals who have been released under that provision of law that allows compassionate release, again, under the SAFE Act. In May, we developed a plan for getting back into the in-person proceedings. As I indicated, we did a trial. Eventually in June, we had a 4-phase plan based upon the magnitude of the virus in the community. And the major things we were looking at is hospitalizations and the utilization of intensive care beds, which is really the prime criteria we are looking at still and determining what steps to take here. We know the numbers are up, but the numbers are also up partially because of the number of testings. So it's critical you look at the hospitalizations. Are the hospitals being taxed at a particular time that's going to cause us to take a step backwards? And it does appear that we're quickly approaching that situation at this time. With the holidays coming up, with the winter coming up, with the cold season and flu season coming up, my prediction is we're going to have to take another step backwards before we go forward. And that's going to be, I think something's going to be dictated by the communities. Both Erie County and Monroe County in particular are seeing large increases in the number of cases, and more importantly, the hospitalizations and the use of the intensive care beds. Just as an example, as I said, we had nobody positive in the Jackson Courthouse up to last Friday. We had one probationer who just came to the Jackson Courthouse some months ago, gave a urine sample and left. And our doctor, Dr. Tassini, indicated that was not a significant contact that we had to be concerned with. But since then, we've had 5 or 6 or 7 now people who have had significant contact with the coronavirus. One of our staff members had the coronavirus herself. And so we're seeing that uptick now that's causing us great concern. We're still going to take a conservative approach. Right now, I have 7 people in either my unit or units I supervise that we have on quarantine right now because of a connection with the coronavirus. As I indicated, we've spent about $50,000 so far in personal protection and cleaning supplies for our different courthouses. We've also spent $30,000 in plexiglass. I don't know if I turn this around, maybe you can see it. Can you see that? I have plexiglass directly in front of me where I'm sitting, but over here is a jury box, which has plexiglass in front of and behind each of the jurors. And again, that was a suggestion of Dr. Tassini. We hadn't thought of that, but to put plexiglass behind the jurors so that if somebody were to sneeze behind them, it would catch that, because that's what you have to be concerned about. But also everything's spread out, as I don't know if you can see the numbers
but we have 14 seats here spread out in the front of the courtroom for the jurors in this case,
which is a jury of 12 and 2 alternate jurors who are spread out in this courtroom. We initially had 25 for jury selection spread out throughout the entire courtroom, and that's worked pretty well. In trying a case, the attorneys stay right at their counsel tables. They don't leave counsel tables. All exhibits are entered electronically so that there's no passing of exhibits between the witness and the attorneys in the courtroom. We have covers on all the microphones so that after somebody talks in the microphone, that's taken off and clean. Between each witness, we take a recess, and the GSA comes in and cleans the witness stand between each witness in order to be sure that that is protected as well. So all those steps we've taken have been helpful at keeping everybody safe. I've conducted a number of these webinars. I've conducted them with the Erie County Bar Association, Monroe County Bar Association, New York State Bar Association, and the ABA, because I think it's important that the attorneys know that we're doing everything we can to keep you and the public protected, and at the same time continuing to conduct our business. One of the confusing terms that's used throughout the proceeding is who's an essential worker. In other words, the travel policy in New York State does not necessarily apply to essential workers. And the U.S. Attorney's Office was able to get an opinion from the New York State Department of Health and the local Department of Health that actually a witness to a grand jury proceeding or trial is considered essential worker, and therefore not required to follow all the quarantine procedures set up on the New York State travel policy. We're all considered to be essential workers. Our staff is essential workers. U.S. attorneys are essential workers. Probation officers are essential workers. However, as I've told everybody, the virus doesn't know that and doesn't care that you're essential, and it can affect you just like anyone else. So the fact you're an essential worker is not going to prevent you from getting the virus and you giving the virus to somebody else. So we still have to take those measures to protect everybody. A couple of other things I just wanted to go over very quickly, and then I think we can open it up for questions, Alexander, if that works for you. As I indicated early on, the civil cases are down probably about 5%. Criminal findings were down 25% as of October 1st, but I think they're starting to come back. As far as vouchers, I indicated attorney vouchers that we've paid last year between April and October of 2019. We paid about $1.5 million in vouchers to attorneys. That same period this year, April 1 to October 1 of 2020, we paid about $2 million to attorneys. So I think that interim vouchers helping the attorneys get paid during this particular crisis. In conducting our business, one of the significant demands we have right now is Social Security cases. We have, believe it or not, more cases in the Western District of New York than they have in the Central District of California, which is Los Angeles. We had 1,600 cases filed last year in the Western District of New York. California Central District had 1,000 cases, a little less than 1,000 cases filed. We have 15 judges, they have 45 judges. So that caseload is something that we are constantly working on to try to keep up with, along with everything else. I just mentioned that because that's something that keeps our staff, even when they're working remotely, quite busy. Some of the things I think advice I'd give to the attorneys during this crisis and how we're proceeding is to be prepared. Be prepared to try a case differently than you would otherwise. You're not going to be up at the podium asking questions. We allow the podium to be used for both openings and in summations. But other than that, you're going to be sitting at the witness or at your counsel table, and that's quite different. You're used to moving around the courtroom, confronting a witness during cross-examination in close proximity, and you're just not going to be able to do that during this crisis because we have to protect the parties. You have to be flexible. Things take a lot longer during these type of proceedings. It takes longer to get into the building. It takes longer to pick a jury. It takes longer to handle exhibits by way of electronic means. So please be patient. And have your witnesses prepared for that as well. And understand that your witnesses might be stopped at the courthouse, not allowed into the building. We had just somebody today, for instance, who was coming, I think, for a grand jury proceeding and was stopped at the front door because they had traveled from out of state, had been tested out of state, but had not been tested here. And under the protocol in New York State, they should not be allowed in the building. Now, they would be essential, and therefore they could get around those travel restrictions. But in this case, we called the U.S. Attorney's Office and talked to them about that, and they were able to reschedule that particular witness. So if we work together, we're all working toward the same end, which is to protect everybody. Things do work out. But prepare your witnesses and your clients that things are going to be different when they enter this courthouse. Because of the fact that everything's electronic, if you're not used to working with our technology, you can get a hold of our courtroom deputies in advance, and they'll work with you to be sure that you can handle the technology in the courtroom in order to present your proof during a particular case. And stipulations obviously help in any case, but particularly along these lines, the less documents that need to be entered, the more stipulations that counsel can enter into help things go much smoother. John, I think that's it in summary. It's quite a summary, I guess, about 45 minutes. But I hope I've given people an idea of what things are like. They're quite different now in our courts. As you know, New York State has already suspended trials, and they really haven't been functioning much during the last 10 months at all. And now they're taking a step backwards as well. And I've been in consultation with them as well. Judge Dorn, who is in charge of jury trials, I think, for the entire New York State, has been consulting with us, and we've been giving them our plans to try to help them out. And of course, their information is helpful to us as well. So we're all working together to try to get through this thing. But Alexander, if you want to open up to questions, that's great.
Sure, thank you, Judge. In case anybody hasn't seen in the chat, the course code for the CLE is court. You'll need that for your CLE credit. Judge, one question that I've been asked is, does the court plan or has the court used more alternate jurors during trials? And what would happen if a juror contracts COVID or comes into close contact with someone who has contracted COVID?
That's a very good question. That's one thing we had to talk to Dr. Tassini about. And the precautions we've taken in this courtroom, the jurors are always wearing masks. They're always socially distanced, and we have them behind plexiglass for that very purpose, that somebody could be bringing in the virus, one of the jurors. And just the fact that one juror proved to be positive for the COVID virus would not necessarily cause a mistrial in that case if we have followed all those strict procedures. So, it's a case-by-case thing. You have to look at it and see, was there any contact with that juror, with other jurors when they were in the break room, for instance? Did one of the jurors go talk with another juror? We'd have to do, an investigation regarding that and make a lot of inquiry to be sure that everybody is safe. But if we follow the precautions with the masking, social distancing, the plexiglass, and the jurors are following that, the fact that one juror proved to be ill during the trial should not necessarily cause a mistrial and a retrial. I have two alternates in this case because it's a short trial. I expect we're going to finish the trial tomorrow over 4 days. So we have two alternates in the event that we need to replace one of them for any reason whatsoever. And that's proved efficient. I'm not sure, Sean, in your case, did you have 2 or 4? 2. They had 2, and you were a 2-week trial, is that right? Yeah. So it was a 2-week trial that they had a criminal case of 2 defendants, and they were able to proceed pretty efficiently along those lines. The number of alternates will primarily be based upon the length of the case. Starting January, I'm supposed to have a 4-month trial. It's going to go from January until April. And in that case, we'll have numerous alternates because anything can happen over that period of time. But typically we go to 2 alternates, maybe 4 alternates. But in that case, we'll probably have at least 6 alternates in a 4-month trial.
Thank you, Judge. How is the Western District handling mediations during the pandemic?
Mediations are continuing in their normal course. Of course, they're conducted within attorneys' offices, not in the courthouse for the most part. And Amanda Williams, who's our ADR coordinator, director currently, continues to conduct mediations remotely. And I believe attorneys are conducting them both remotely and in person if that's appropriate. But we have not cut back on mediations. They've continued in their normal course.
Another question we've been asked are there any changes that have been made to the court proceedings that you think will outlive the pandemic?
Yeah, well, I'm hoping that the remote proceedings will outlive the pandemic. As I indicated, it's part of the CARES Act that amends the criminal procedure law, the federal procedure law, that allows us to conduct remote proceedings for arraignments, initial appearances, sentences, pleas. Normally, we would not be able to do that remotely. And I'm advocating for that. And I've actually been in contact with my local congressman to submit legislation so that will survive. And here's why I think it's a no-brainer, is because it requires the consent of the defendant. So if a defendant feels that they want to be present in the courtroom, the attorney feels the client needs to be present in the courtroom, then they have to consent. And for the most part, as I indicated early on, the defense counsel and the U.S. attorneys have been very cooperative in consenting to those procedures. But on other occasions, if a defendant, and we've had a number of those, for sentencing in particular, they want to be present in the courtroom, be there when the judge is there, talk to the judge directly, then they would be allowed to do that. So I do see that surviving beyond this crisis. And I think that's very efficient. If you think of it, how many proceedings do attorneys attend that are 5 minutes for an adjournment to a new date? So you're leaving your office, you're breaking from whatever you're doing then, coming down to the courthouse, appearing before a judge, taking 2 minutes to ask for a 2-week or a 3-week or a 4-week adjournment, and then going back to your office, where you could do it right from your office in a matter of moments. And I think that's, people are getting more comfortable with these remote proceedings for those situations. And I think that's going to be appropriate. Now, remote trials, I know they've conducted one, at least in Texas. They conducted a remote civil jury trial. And I'm not sure that's going to be a wave of the future because the control over jurors, what they're doing in their living room and who is influencing them while they're deliberating or listening to evidence, who else is listening to evidence and influencing that juror, is something that you lose control of very quickly. I haven't heard a report yet on how well that went, but that's not something I think that would be survive this crisis to any magnitude. Maybe it could occur in some proceedings. Certainly bench trials could be done remotely. Certainly testimony from experts and other witnesses could be done remotely. But I think civil jury trials, certainly criminal jury trials, I don't see that being conducted in a remote fashion.
Judge, if it hasn't already, do you think a juror's fear of contracting COVID will become a threshold and disqualifying question that judges will ask at the outset of jury selection?
Well, we do currently screen jurors. In other words, they get a questionnaire before they're ever brought down to the courthouse regarding any concern about COVID, any contact with COVID, anything that would cause them a concern. So when we bring the jurors in, for instance, I had 100 jurors summoned for this trial. All of those jurors had already agreed that COVID was not an issue for them, and they had agreed to come down to the courthouse. Now, one concern raised by defense counsel, just not officially, but in mention, was the fact, is that going to affect the diversity of the jury panel? So we specifically had our jury administrators keep track of that. In other words, were we losing minority jurors? based upon COVID more than non-minority jurors. And we found that was not the case at all, that it was not affecting the diversity of the jury panels that were coming down to the courthouse and agreeing to serve. So, you know, I think we screen out the COVID questions in advance, and that's been very effective.
Another question we've been asked, is the court doing anything in particular to prepare for the expected rise in our area to orange and red status?
But yeah, quite frank, I'm going to have a meeting with the judges probably the next day or two to decide how we should proceed. And that's why I'm always looking ahead at our trial schedule right now. I believe we have 2 or 3 criminal trials scheduled in Buffalo between now and the end of the year. I don't think we have any more scheduled in Rochester once I'm done with this case. I have 2 civil trials scheduled in Rochester. I could see that we could try to move those trials. The criminal are much more difficult, of course, because defendants have a right to a speedy trial. But in the civil cases, particularly the 2 I have, are prisoner cases. And I believe the state facilities are starting to lock down again. They're not allowing visitors, and they're probably not going to transport prisoners. So those pro se litigants, plaintiffs in those cases probably aren't going to be able to be brought here in any event. And that's going to affect those trials. So I could very well see that if the numbers continue to increase, that we'll have to take steps about not conducting additional trials and also possibly going more to remote working.
Another question we've been asked, Judge, is have there been any challenges from counsel regarding jurors wearing masks?
Any what? I'm sorry?
Any challenges from counsel regarding jurors wearing masks? And if so, how have they been handled?
There was in Buffalo. I don't think there has been any challenge in Rochester or for the most part in Buffalo. There was a challenge early on. And the question was whether or not, we actually had a task force put together on how to conduct jury trials, which included the Federal Public Defender's Office, U.S. attorneys, CJA attorneys, staff members of the court in order to handle issues such as that. And one of the concerns was for the attorneys to be able to look at the expressions of jurors. And we had the availability of masks that are clear, so you could actually see their facial expressions. They're extremely expensive. I think it's $3 to $4 per mask. So that it's not very practical to try to do that. And we've had really no pushback from attorneys for the most part in jurors wearing their masks. And we give them our masks. We give them the blue mask, the blue surgical mask that we ask them to wear because that's what the doctor said to be consistent. Make them wear your own mask. We've had a couple of jurors who didn't like wearing masks, and in that they don't have a choice. I mean, they have to wear masks, period. And we had one juror in this case, in my case, who indicated that she'd never had a mask on for so long and she couldn't breathe. And after I talked to her for a while, she forgot she had the mask on and she was fine about it. So she's now actually sitting on that jury. So, you have to work with people, try to alleviate their concerns and their fears. It's legitimate for attorneys to say, we want to see the jurors' expressions, the witnesses' expressions, in order to judge them. But they've been very cooperative. By the way, the witnesses we do have in plexiglass, if you can see here. I don't know if you can see it. Well, we have them encased in plexiglass on both sides so that they do take off their masks. So a witness when testifying does not have a mask on. And I allow the attorneys as well to remove their mask while they're asking questions for a lot of reasons, including the fact that the court reporter, it makes it much easier for the court reporter to hear them and to make a good record.
And this will be our last question, Judge, before we wrap up. Are court librarians working remotely? And if so, are they still able to assist attorneys with research questions?
The court librarians?
Yes.
Yes. They're working remotely. And if you have any questions or concerns, feel free to contact them or contact the clerk's office, and they can in turn make sure that you're in contact with the court librarians.
Okay, well, thank you very much, Judge. Our time's up. And, once again, thank you, Judge Geraci, for taking time this morning and keeping us all updated on the situation in the Western District.
Well, thank you for having me. And Alexander, you did a great job, and UB Law School. I appreciate it. If you have any concerns or questions, don't hesitate to call the clerk's office or call me directly, and I'd be happy to address your concerns.
Thank you very much, Judge. And to our attendees, you'll be receiving more information about future CLEs. Our next one is scheduled for December 3rd, How to Read an Insurance Policy and Actually Understand It, featuring John Ewell, an associate at Gerber, Ciano, Kelly, Brody as our presenter. And everyone, please be sure to send in your attorney verification form and our program evaluation form to Pat Warrington so you can receive CLE credit. And once again, our course code was COURT. Thank you very much, everyone, and special thanks to Judge Geraci for joining us this morning.
Thank you, Alexander. Thanks, UB Law School. Take care. Good luck, everybody. Be safe.